Okay, so in this section, I'll be covering Tadros' fairness-based argument for non-combatant liability. In some circumstances, the death toll would be reduced if the judge side-tweaked the principles of jus in bello to allow the relaxation of the principle of non-combatant immunity. In doing so, this also distributes the risk of being maimed and killed more evenly. These facts themselves significantly support non-combatant liability. Tadros is arguing here that although it is primarily combatants who pose threats, it is only fair that non-combatants are also liable. This section covers the features of vicarious liability that Tadros was arguing for, which relies on distributive liability. Part 1 to 3 covers Tadros' case for vicarious liability of non-combatants. Part 4 covers the implications of these, and Part 5 covers on cases where young children is involved. In Part 1, Tadros covers avoidability and attribution. This section centers around the idea that combatants' degree of responsibility for posing threat becomes an important factor in perpetrator-centered case for vicarious liability. The justification of vicarious liability weakens when the perpetrator is more responsible for the harm caused. In this case, Tadros sees the responsibility of perpetrator as a spectrum instead of it being black and white. Therefore, the degree of responsibility of perpetrators depend in part on how difficult it is to avoid posing the threat or causing the harm. This means that the claims to vicarious liability weakens if it is easier for the perpetrator to avoid posing an unjust threat. In other words, those who act reasonably or who are negligent have more powerful claims that others share liability with them than those who are highly culpable. Tadros acknowledges that it is sometimes difficult for combatants to avoid posing unjust threats to others. Reason being is based on the evidence combatants have. Some unjust combatants are justified in threatening others. Evidence relative justifications do not typically vitiate liability. And another reason is the fact that it is out of self-defense. A person who mistakenly threatens me with little force is liable to be harmed to avert the threat that she poses even if her mistake is reasonable. Tadros also highlights the limitations and constraints of combatants. This is due to the lack of facts and the lack of expertise. Combatants are not in a good position to identify the facts relevant to determine whether threatening others is justified. And even if they do know the facts, it is difficult for them to accurately evaluate them. Another limitation is due to the high-ranking personnel. This includes the combatants' commanders or the government officials who have more evidence than they do and more expertise in evaluating it. Combatants are also conditioned to trust those of higher ranking than them. Tadros also admits that combatants have a range of familiar excuses for going to war even if they believe it is not just. Temptations to treat commanders and government officials as epistemic and moral authorities. This is since military training conditions combatants to unquestioningly follow commands. Combatants also act under duress and are subjected to significant social pressure to fight from their peers. The facts mentioned help to explain the intuitive difference between bomb disposal and end the war. In bomb disposal, it is easy for the villains to refrain from acting wrongly. In other words, their actions are avoidable and attributable to the villains. However, this is not the case for end the war. This distinction supports Tadros' verdict that the combatants in end the war are not liable to be killed. Their liability must be coupled with a lesser evil justification to warrant killing them. This also brings an implication that these combatants have a more powerful case against being solely liable to avert the threats they pose. Tadros also foreseen some objections and attempt to formulate a reply. The first is, some might argue that vicarious liability is diminished when intentionality comes into play. When a person intentionally decides to threaten others, she is deeply responsible for her own actions. Degree of responsibility is dependent on the relationship between the threat and one's agency. Intention is central to agency. Therefore, responsibility increases when a person intentionally poses a threat than doing so negligently. However, linking back to combatants, their actions are highly responsible as it is intentional, but Tadros only claims that this weakens shared liability instead of entirely diminishing it. The second objection The second objection may be the fact that others might argue that vicarious liability should only be decided by normative relations between people and not by someone who poses threats. But Tadros argues that to examine that if a person is vicariously liable, it is necessary to compare them against the perpetrator. This is because distributive liability is dependent on the sole responsibility of perpetrator for posing or responding to the threat he caused. Tadros acknowledges here that distributive liability weakens consideration that our response is dependent on the depth of our responsibility, and those intending to pose threats are more deeply responsible for those threats. And the last objection is that others might reject this argument on the basis that the kind of responsibility that is relevant to a person's liabilities depends solely on avoidability and not on attributability. Tadros emphasizes here liability depends on both avoidability and attributability. Bad outcome contribute to us and when bad outcomes are attributed to us, when bad outcomes are attributable to us, this makes it more stringent for our obligation to respond to the threat. And because of this, it is easier to justify imposing burdens on us to avert it. Tadros acknowledges that the deep responsibility of combatants for the threats they pose counts against the vicarious liability of non-combatants. Tadros notes that though these considerations are important, it is not decisive. The fact that the threats that combatants pose are deeply attributable to them needs to be balanced against the fact that they are usually act either reasonably or with some excuse. The difficulty of avoiding posing threats to others is sufficient to support some measure of vicarious liability, even for threats deeply attributable to the perpetrators. Moving on, Part 2 covers the relationship between combatants and non-combatants. Vicarious liability depends on there being a special relationship between the perpetrator and those who share liability. There are several considerations that make relationships sufficiently special. Vicarious liability is more familiar as a legal than a moral idea. In law, relationship between employers and employees is central. Adopting the context of law to the case here, both victim-centered and perpetrator-centered considerations are crucial in explaining vicarious liability. In law, its central ambition is to ensure that employees do not bear the sole burden of their harmful conduct. Similarly, in this case, the central consideration that justify the impositions of vicarious liability on employers also apply to the relationship between non-combatants and combatants. Next, one consideration concerns benefit. To examine who benefit from the combatant's role and how much, it is necessary to consider both the actual combats and also combatants' conditional intentions. Caveats to note are, first, not all combatants in all circumstances benefit from a standing army. Tadros' argument only applies to those who do. And second, not all wars are conducted for the benefit of non-combatants. Non-combatants are not liable to share in the cost of wars that are purely aggressive. The caveats emphasize that Tadros' argument only applies to threats posed in the course of wars that aim at protecting or otherwise benefiting non-combatants. Benefits that non-combatants reap from a standing army that protects citizens is 1. If it wasn't for the willingness of combatants to pursue a military career, non-combatants would have been required to do so. In the absence of a standing army, a country may be vulnerable to attack by aggressor states, at least if it lacks international protection. A state that lacks sufficient volunteers must rely on conscription. Those conscriptions would then have to make the kinds of difficult decisions that combatants make. For the reason outlined in this section, these combatants would typically have done no better than the combatants. One possible objection from this is the claim that benefiting from an activity is insufficient to render a person liable to share in the cost associated with it. Tadros adds Robert Nozick's famous example to intuitively support the objection. This example is called public address, which is placed on the slide, and some people contribute to the provision of whereby some people contribute to the provision of public entertainment through a public address system benefiting others. Nozick plausibly argues that beneficiaries of this scheme are not required to contribute to it. Following that, similarly, one can argue that the fact that non-combatants benefit from the activities of combatants is in fact insufficient to render them liable to bear costs to protect combatants. Tadros argues that though Nozick's case may seem intuitive, the fact that a person is a beneficiary of the cause of conduct that gives rise to the harm is a central part of a more complete case for vicarious liability. He furthers on to contrast the above scenario with liable benefactor. In liable benefactor, X is in a coma and is vulnerable to attack. Y takes it upon herself to protect X. Because she forms a conditional intention to protect X, others are deterred from unjustly attacking X. Furthermore, Y successfully wards off some unjust attacks on X. X then wakes up and immediately discovers what Y has done. He also realized that Y has negligently mistaken Z for an unjust threat. Y is now attacking Z to protect X, and Y cannot be prevented from doing so. Tadros notes that Y is liable to be harmed for negligently posing as unjust threat to Z. He furthers to note that X may not be required to give up his life for the sake of Y, but at the very least, on an intuitive level, X is required to share the cost with Y if he can. Moving on, there's a range of factors that is relevant in explaining the intuitive contrast between public address and liable benefactor. First, nature and magnitude of the cost that is concerned with. It might be thought that this counts against vicarious liability in liable benefactor. This is because the cost that X will bear if he is vicariously liable is not simply a financial cost. He will also suffer physical harm. However, if X is not vicariously liable, Y will be fully liable to bear a cost that is also physical. Similarly to the financial cost in public address, Tadros notes that physical harm also comes in degrees. He attempts to appeal to our intuition that it is typically preferable to divide cost among a population rather than concentrating the cost on fewer people, regardless of the nature of cost. So this could mean money, time, or physical harm. He then claims that if people accept the intuitive notion of distributing financial cost, it would be the same towards physical harm. Going back to liable benefactor, Y's action ultimately benefits X by protecting X's life, not by providing more entertainment such as in the case of public address. Therefore, the more significant the benefit, the easier it is to justify dividing cost between perpetrators and beneficiaries. Second, why X for X's sake? Though Y mistaken Z for an unjust threat, Y actions are based on goodwill to protect X. Furthermore, many acts carried out as part of this plan were successful in protecting X and were fully justified. Therefore, in such cases, vicarious liability is more inclined to be imposed on X. Thirdly, Y faces significant risk in executing the plan to protect X. Risks faced by people who execute plans for the protection of others are significantly increased if vicarious liability is not imposed in cases such as liable benefactor. However, looking at the case of public address, providing an entertainment system is not significantly burdensome, so there is less pressure to divide the cost of provision. And lastly, X would appreciate the protection from Y. Since X is in a coma, he is unable to protect himself from harm. Intuitively, we would agree that X would appreciate the protection that Y provides. However, it just comes with the condition that would render X liable to be harmed to avert threats that Y negligently pose. Next, another consideration that Tadros considers is concerning consent. Following the fourth factor, this brings up another consideration concerning consent. Public address demonstrate the fact that a person would have wanted a task performed at a certain cost is insufficient to justify imposing a cost on that person in the absence of actual consent. Usually consent is needed, even though there is every reason to be confident that consent will be given. When the task performed by one person for the sake of another, but the other will need to also bear certain costs. Seeking consent is to ensure that a person's affair is under their control. Looking back at liable benefactor, Y cannot consent. At best, out of respect for X's autonomy, Y can also put himself in X's shoe to consider if X would have consented to the protection. Consent on X's part is based on the conditions that he accepts the distributive cost if Y were to negligently threaten others unjustly. In this case, it would be easy to justify imposing these costs on X. But what if that is not the case? When consent cannot be sought, though, the fact that the person would have consented to share the cost of the behavior makes a difference to justifying imposing those costs on her. Tadros notes that hypothetical consent may not be decisive alone. It does not meet a complaint that a person might make against vicarious liability that she is required to share in the burdens of a project that she has not agreed to support. This can draw parallels between the relationship of X and Y in liable benefactor and the relationship between combatants and non-combatants. Tadros also argues that consent may not be as important in his argument in vicarious liability because 1. Role of combatants is for the sake to protect non-combatants. Second, non-combatants benefits from combatants' contribution. Not only that, but they are the intended beneficiaries of the willingness of combatants to fight, to go to war. And third, combatants bear significant risk in protecting civilians. Fourth, combatants reasonably believe that combatants would consent to them performing the task, even if non-combatants were required to share liability in the case of negligent mistakes. Fifth, combatants cannot seek the consent of each civilian to perform the task of protecting them. At most that they can do is to rely on the decisions of their superiors. With that being said, there could be a possible argument whereby if someone disagrees with the war, they could just march with placards that they declare that war is not in their name and be excluded from liability. However, Tadros rejects this argument on the basis that non-combatants cannot expect combatants to respond to their particular demand that a war is unjust. If non-combatants benefit from a standing army and cannot expect combatants to respond to their individual judgment about war, they also cannot expect to be excluded from sharing liability on the grounds that they disagree with the prosecution of any war in particular. In summary, for this section, essentially, though this section of Tadros' paper is very lengthy and dense, what he is trying to say is that so long as a person benefits from something, it does not matter if they consent to it or not, they are still vicariously liable. However, this seems rather problematic to simply disregard consent and rely on the benefits that civilians gain. This issue would be brought up again at the end in one of our responses. So moving on to the third part. In this section on consent, Tadros anticipates an objection that in deciding to serve in armed force, combatants voluntarily accept that they will shoulder the cost of war. This means that liability ought not to be shared with non-combatants. However, Tadros provides 6 reasons that non-combatants is still vicariously liable. The first reason is the fact that argument only applies to volunteers. There's an implication that volunteers are willing to sacrifice themselves for the sake of others. Many combatants fight in part for the sake of non-combatants. Though they may value their protective role, it doesn't mean that they see the inherent risk as a value. Instead, combatants value the cause instead of the risk involved in achieving the cause. Many combatants may regret than relish taking these risks. Second reason being during moments of death, the combatants may change their mind. Combatants who value sacrificing themselves for others when joining the military need not be willing to sacrifice themselves for the sake of non-combatants at the moment when they are about to be killed. If there is no good reason to think that combatants are willing to sacrifice their lives for non-combatants at the moment of death, any general consent of combatants to put themselves at risk for the sake of others is irrelevant. The third reason being is the repercussions on death toll. Combatants who are willing to sacrifice themselves for the sake of non-combatants may not be willing to do so when this sacrifice increases the overall death toll. They may be willing to sacrifice themselves only on condition that doing so saves lives overall. The fourth reason being outrageous expectations. The fact that a person has voluntarily entered into a role that has certain expectations attached to it does not imply that those expectations are just. Bringing back the scenario on work. Even if Y has expected to bear all the costs of his negligent work, imposing those costs on him would be unfair. The fifth reason being socio-political pressures regarding job opportunities. In many jurisdictions, combatants typically come from difficult social circumstances where their employment opportunities are limited. Their choice to join the military is heavily constrained and unjustly so. This injustice is exacerbated by a strict principle of non-combatant immunity. The idea that the armed force consent to bear the cost of war may have greater moral significance in more ideal social circumstances. And lastly, overly glorifying the role of combatants. The idea that the role of combatant is ennobled if combatants bear sole liability for unjust threat that they pose is exaggerated. Relaxing the principle of non-combatants' immunity would not erode the value of the military role, and it is difficult to believe that those on the just side should choose to kill combatants rather than non-combatants in cases such as whether to delay for the sake of the nobility of combatants. And moving on, part 4 covers the implications of vicarious liability of non-combatants. There are important practical implications that non-combatants are vicariously liable to be harmed, even to a degree less than death but not to be killed. Bringing back whether to delay and end the war, those non-combatants that are killed are wronged because they are vicariously liable to be killed. The first part being, many attacks in war are not certain to be lethal. It is not necessary during war to target non-combatants. Even if that is the case, the main aim is not to kill but simply to prevent non-combatants from contributing to the conflict. Harm intentionally inflicted on non-combatants that does not cause death to prevent them from contributing to the war is not wrong on the combatant's part. The extent of a person's liability to be harmed makes a difference to the permissibility of killing the person. As suggested by Tadros earlier, permissibility of killing a person does not rely on her being liable to be killed. The fact that killing a person wrongs her does not imply that it is wrong, all things considered, to kill her. A person's liability alters the proportionality calculation, helping to justify killing the person. Combatants are liable to be killed only if they have a high degree of culpability and causal responsibility for the threats they pose. Tadros does not believe that a person's right to life should be taken away from them just because the person is taking a reasonable risk or being negligent in posing a little threat to others. And in the last section, Tadros does not include children from liability, contrary to other arguments that support immunity of young children from liability. He argues that children may occupy any of the roles that was previously discussed. This includes combatants, civilians that contribute to war by helping to build munitions, or non-combatants. With the reasons that Tadros pushes forth is, first, it averts the greater evil that is caused by children. This is on the basis that killing child soldiers on the unjust side may be necessary to avert the threats that they pose to greater number of individuals. And second, appealing to our intuition, it is permissible to kill a non-responsible attacker to prevent that person from killing a greater number. Tadros does not see that there is anything different when it comes to the case of young children. And the third reason being, lacking capacities required to have certain duties does not render that person immune from having cost imposed on her. Some may regard children as a special case in virtue of the fact that children are incapable of owing duties to support combatants in their roles. Tadros argues against this, as this would mean that the liabilities of adults and children may differ because only adults and not children have the duties, which he disagrees. An argument against the vicarious liability of children depends on the special reason that we have to protect children from harm, and not on the fact that they lack the capacities necessary to have duties. Therefore, ultimately, regarding young children, Tadros rejects that they are immune to sharing the cost of war. Thank you.